Hello everybody, my name is Rishabh. This is our revision lecture number 2 of SPOM Set A Corporate and Economic Laws. This is MCQ Oriented revision lectures for your SPOM examination. For all of you who doesn't know, we will be covering all the important chapters of SPOM Set A Corporate and Economic Law in the next few days, so that everybody can score good marks and clear it in the very first attempt. If you are somebody who is new to this channel, please do subscribe to the channel and let me know in the comment section if you have any particular doubt relating to all these lectures that I am going to upload in the next subsequent few days. In this video, we are going to cover your chapter number 1, that is appointment and qualification of directors. This is a very most important chapter of your entire syllabus, of Set A. And all the 3 chapters, that is directors, first chapter, that is appointment and qualification. Number 2, your board meeting and its power, and the last is managerial remuneration. If you combine all the 3 chapters together, this will easily fetch you more than 15 to 20 marks. Matlab minimum to 15-20 marks is mandatory from these 3 chapters that I have. This I am talking based upon the experience what I have spoken to many of the students, many of my friends, many of the subscribers on the YouTube. So this entire PDF what I am going to discuss in this particular video, you will be able to find out this in the below attached Telegram channel, the link of which is given into the description. Please do join that particular channel and you will be able to access this document along with the other chapters, summary notes, chart form summaries I have also prepared. That also I will be posting on that channel only. So please do join that channel and please do comment if you like the video, share it with your friends so that they can also be getting benefited and crack the examination in the very first attempt. Now, without wasting much of time, let us begin. तो सबसे पहले बोर्ड ऑफ डायरेक्टर्स, बोर्ड इज कंसिस्ट ऑफ डायरेक्टर्स, जिसके बारे में हम लोग पूरे चैप्टर के अंदर इन डिटेल डिस्कशन करने वाले. Now, the first provision, section 149, subsection 1 says minimum number of directors. Every listed company, every kind of public company, private company, or one-person company, what is the minimum number of directors that is required? One-person company, 1 director. Private company, 2 directors, and the public company shall have minimum of 3 directors on its board. Minimum directors. Maximum directors कितने हो सकते हैं? Maximum directors should be 15. But in case a company passes a special resolution, then there can be more than 15 directors also. The limit of 15 directors is not applicable in case of a company which is a government company and also in case of section 8 company. 15 directors ka limit not applicable for a government company, for a section 8 company. Please read this chart, self-explanatory chart is given for your reference. Second proviso to section 149 subsection 1 says that talks about woman director. Every company shall have at least 1 woman director. Before starting this, let me tell you, this is the one of the most favorite question of ICA. ICA is asking question on this particular provisions in every examination of SPOM. So please pay attention to this provision. The provision says number of woman directors shall have at least 1 woman director. In what kind of companies? Every listed company can also be a private company also. It is not necessary that all the public companies will be covered under listed. The word listed definition covers both private and public limited companies. Private limited companies are those whose securities like such as debentures or debt instruments are listed on institutional trading platform. ITP पे जो भी listed होते हैं उनको भी are considered as listed company, and the requirement of woman director is also applicable for that kind of private limited companies also. Every other public company, please focus on the word every other public company. Here only public companies are covered, having paid up capital of 100 crore or more, turnover of 300 crore or more. Either of the condition is fulfilled, you need to mandatorily have at least 1 woman director on your board. Now the next provision talks about in filing of intermittent vacancy. If woman director resigns or dies or anything happens, there is a vacancy of woman director, then that vacancy is to be fulfilled within 3 months from the date of such vacancy or the next board meeting whenever it is held, whichever is later. Let's say a woman director left the organization, left the company on 21st of July. Now the 3 months you should count from 21st of July. The 3 months will end on 21st of October, and let's say the board meeting happens on 30th of November. So the maximum time limit up to which the vacancy should be filled is 30th November, whichever is later wala criteria is applicable. Now this one you read yourself. The last audited date of financial statement should be considered. Meaning of resident director, section 149 subsection 3 says every company shall have at least 1 resident director who shall be resident in India for at least 182 days. मतलब कम से कम 182 दिन, 182 days he should be there in India. In case a company is in existence for less than 1 year, then this requirement will apply proportionately. Proportionately this requirement is to be applied in that particular case. Independent director, again one of the very most important questions are being from this particular topic also. every listed public company, यहाँ पे listed public company है, here it was only listed company, so listed that the woman director में listed include your private and public both, but in case of independent directors only public company के लिए independent director requirement is applicable. So please pay attention to this. Only listed, every listed company, listed public company having shall have minimum of 1/3 of total number of directors as independent directors. Let's say total number of 9 directors are there. So at least 1/3, that is 3 directors should be independent out of total 9 directors. Every other prescribed class of companies like public company, only public companies के लिए independent director is applicable. So paid up share capital of 10 crore or more, turnover of 100 crore or more, outstanding loan debentures more than 50 crore. Please pay attention to this sign, more than 50 crore. It is not more than equal to 50 crore. So please be careful with this particular limit. So these kind of public companies which are not listed, which are unlisted public companies, at least 2 independent directors should be there on their board. Now this one, higher number of independent directors. If any committee requires, in case of SEBI LOD or audit committee requires more number of independent directors, so then independent directors should be according to that particular committee. Now who can be independent director? A person should not be. So I think this independent director, I don't think so any kind of question can be framed, but still for a reference this is given for your reading, so please give a reading on yourself. I have mentioned the relevant notes over here on the left hand side. This one also you should be reading yourself. Okay, now let us move on to the subsections. Clause A of section 149 subsection 7. It says submission of declaration by independent director. Independent director is required to submit a declaration of what? Every independent director is required to file a declaration at the first meeting of the board that they meet the criteria of independent director. Whenever he is appointed a director and the next subsequent meeting when he is attending as position as independent director, he should declare himself as an independent director, and he is required to every subsequent meeting of the financial year he is also required to mention that he is an independent director. That is all about is mentioned in this particular section. Now 149(8) says that every company and independent director shall by provisions of schedule 4. तो schedule 4 के अंदर जो भी provisions दिए उनके साथ comply करना जरूरी है. Moving on to the next page, whether independent director can have stock options or not, a very good question can be framed from this. Independent directors cannot have stock options. What he is entitled to, he shall not be entitled to any kind of stock options, but he is entitled to the remuneration according to section 197 subsection 5, reimbursement of expenses for the attending of board meeting, and profit related commissions if it is approved by the board members. So this is only he is entitled to. He is not entitled to any kind of ESOPs. Please take care of this in mind. Tenure of independent directors. तो independent director का tenure क्या होगा? 5 consecutive years के लिए he can be appointed as a director in 1 year. In the first instance, he can be appointed as a director for 5 consecutive years, and he can be reappointed for another term of 5 years by passing a special resolution by the board of directors. अगर special resolution pass किया, then he can be appointed for the 2 terms of 5 years is the maximum. He can be appointed for 2 terms of 5 years each. After that, there should be cooling period of minimum 3 years. There should be 3 years of cooling period up to which he shall not have any kind of transaction relationship with the company. This one we have covered. Okay, that's all about in this particular thing. Liability of independent director. He shall be liable for all the acts which has been conducted in keeping him in knowledge. मतलब a person who is having knowledge of intentional omission, then he shall be responsible for those acts. Otherwise, he shall not be responsible for the acts which are conducted for which he was not aware. Okay. Now retirement by rotation. So retirement of rotation, independent directors के लिए retirement by rotation की provisions are not applicable. This provisions we will be going to discussing in the section 152 that is coming in the next 1 or 2 pages. Now moving on to the remuneration of independent directors. So as we mentioned over here, point E and point I are kind of similar, so you can read it on your own. Now small shareholder director, very important questions, very important provision from which questions are being asked in every question paper. I would say in my examination, woman director question came, SSD came, along with that independent director also came. So please give proper attention to this particular small shareholder director provisions. Is the company required to have mandatorily required to have small shareholder director? The answer is no, it is not mandatory. It is dependent upon the company's management whether they want to have or not. What company should have? At least every listed company shall have independent director only. Small shareholder director may or may not have. Only listed companies are required to have. Only listed companies के लिए small shareholder director provisions are applicable. Minimum 1, मतलब एक ही independent director, एक ही small shareholder director होगा. बार-बार independent आ रहा, sorry for that. Only small shareholder director होगा, वो ही एक होगा खाली, ठीक है. who is a small shareholder? तो small shareholder का definition is mentioned, who is having shares of not more than 20,000 rupees of nominal value. मतलब the nominal value, the face value should not exceed 20,000 rupees. Now how to appoint a small shareholder director? So इसके अपॉइंटमेंट के लिए नोटिस कैन बी गिवन बाय एटलीस्ट 1000 स्मॉल शेयरहोल्डर और 1/10 ऑफ टोटल नंबर ऑफ शेयरहोल्डर्स whichever is lower. अगर 1/10 of small shareholders or 1000 of small shareholders, either of them serves a notice, whichever is lower, either of them serves a notice to the company for appointment of director, some appointment of a person as small shareholder director, then such person may be appointed as small shareholder director. Notice should be given at least of 14 days. That is missing over here. Please add into your notes. At least 14 days का notice देना पड़ेगा for the appointment of small shareholder director. Small shareholder director is also not liable to retire by rotation. The period for which his appointment shall not exceed 3 years. तो मतलब 3 साल के लिए he can be appointed as a small shareholder director. Apart from this, there is a 3 years का cooling period for which the small shareholder director shall not hold any kind of position, any kind of transaction, any kind of relationship with the company. So 3 years of tenure, 3 years of cooling period also. Apart from that, can a small shareholder be a director? So this particular question was asked in my examination. Can a small shareholder be a director in more than one company? The answer to the question is yes. He can be a small shareholder director in maximum 2 companies, provided the other company is not in the same business. Let's say company X is into the textile business, company Y is also into the textile business. Then in that case, he cannot be appointed as small shareholder director in company Y. He can be appointed as small shareholder director in either of the companies. Now the cooling period of 3 years, this one also we have discussed. Now here is a small chart for your reference. The requirement of retirement of director by rotation is not applicable for independent director, small shareholder director, nominal director, alternate director, and additional director also. Please read this chart carefully. A question can be from this particular topic also. The retirement of directors provisions we are going to discuss in the subsequent part of this chapter. Now section 150 says that manner of selection of independent directors and maintenance of data bank of individual directors. Kindly refer ICA module. Page number I forgot to mention. When I upload this PDF on the Telegram, I will be updating the page numbers over there. Section 152, appointment of directors. When to appoint a director? So the name appointment of directors should be, the name of directors would be mentioned in the article of association of the company. But in case the one director's name is not mentioned, then the subscriber to the memorandum shall be considered as directors until they are reappointed by the members in the general meetings. So this is the requirement with respect to appointment of directors. Now no person shall be appointed as directors unless he or she is having a director identification number. So DIN के related जो भी provisions है, for which also I will be providing you the reference number in the next page. You should definitely go through those provisions. I don't think so these are much relevant provisions, but still you can have a glance over it. Now section 152 subsection 6 talks about subsequent directors. Now who should be a subsequent director? Now the retirement of director by rotation to avoid self-perpetuating management. So why there is a requirement of rotation of directors? It is talking about all that. At least 2/3 of the total directors shall retire by rotation in the general meeting. 2/3 of directors shall be eligible to retire by rotation. Out of those 2/3, 1/3 shall retire in the next AGM, annual general meeting of the company. Let's say there are total number of 9 directors, out of which 2/3 are eligible to retire by rotation. 2/3 would be 9. 9 ka 2/3 will be 6. Out of 2/3, 1/3, that means basically 2 directors shall retire by the retire in the next AGM. So for your easy reference, I have also mentioned the example for this also. So please refer to this example. What if the AGM is not held? So then what is the last due date to conduct the AGM? It is 30th September in most of the cases. So up to that date only the director shall be retired by rotation. Now how to select the directors? The longest officer, so you read it yourself, you will be able to understand it very easily. If I read it, the video duration will be lengthy, so I am avoiding this particular topic also. Now section 153 to 159 talks about director identification number. I would recommend you to kindly refer ICA module. Okay, now section 160 talks about right of person other than a retiring director to stand for directorship. If I am somebody, if I am Rishabh, I want to have a directorship in, let's say, Reliance Industries. So what are my rights? Can I be a director in there? So for that I should definitely have a director identification. That is the first requirement. Apart from that, I should be submitting a notice to the company before the general meeting. 14 days notice is minimum required by the member. Either the member themselves can submit, or I can also submit saying that I want to be a director in this particular company. Deposit is to be made of at least 1 lakh rupees. 1 lakh rupee ka deposit I have to make. 1 lakh rupees of deposits I have to make to the company to be appointed as a director in that company. Now, what if I am not being appointed as a director? If I am not appointed as a director, in that case, what will happen? So, iske baare mein we will, we will understand in this particular chart. Let's say I get more than 50% of votes, then he will be considered as a director. Apart from that, the deposits of entire 1 lakh would be refunded to me. If more than 25%, then no refund would be granted. No, I will not be a director, but refund would be granted. But in case the number of votes that I get is less than 25%, then in that case I will not be considered as a director, and my refund also be forfeited by the company. This one you read it yourself. This one is fine. This one we have discussed. Now deposit of 1 lakh will not be applicable in case of whom? In case of an independent director, in case of director who is recommended by nomination and remuneration committee, and director who is recognized by the board. In those cases, a person is not entitled for making of deposits of 1 lakh rupees. So deposit 1 lakh rupees criteria is not applicable in these cases, right? Yeah. Okay, this one is fine. This one we have discussed. Now moving on to the additional directors provision. Section 161 subsection 1. What does this talk about? It talks about appointment of additional director. Now A of article of association of a company may confer on its board of directors the power to appoint any person as an additional director in the company. Now, who fails to get appointment as a director in the general meeting cannot be appointed as an additional director. He is disqualified to be appointed as additional director. Term would be, what would the term of additional director? He should hold the office up to the next annual general meeting or the last date up to which the AGM should have been held. When is the what would be the tenure of additional director? The tenure would be the last date of the AGM and the general meeting, or the date on which the AGM is held, whichever is earlier is the last date for his tenure. So I would say its tenure would be a minimum of will not be more than 1 year. Now, moving on to the provisions of alternate director, section 161 subsection 2. What does it talk about? It talks about appointment of director, alternate director. Let's say a director is going out of India for a period of more than 3 months. Then in that case, that director may request board of directors to appoint any person as an alternate director. Okay. So this is the provisions with respect to alternate director. Board of directors, if authorized by article of association, may appoint any person as alternate director, or a resolution should be passed in the general meeting if a person is to be appointed as an alternate director. Time of appointment so minimum of 3 months the person should be absent from India. The main director should be absent from India for minimum period of 3 months. Exception: no person shall be appointed as alternate director if he is holding any kind of alternate directorship or any other directorship in the same company. If a person is nominated as to be appointed as alternate director, but he is also holding directorship in the same company as an alternate director or any other kind of directorship, then that person will not be entitled to be appointed as alternate director. Now, term of holding office, not until the period permissible to the original director. Automatic reappointment apply only to the original and not applicable to the alternate director. So in case of alternate director, automatic reappointment is not applicable. Now moving on to section 161 subsection 4. This talks about appointment of director through casual vacancy. Let's say a particular director during the course of his tenure dies or retires on his own willingness, then in that case how his appointment is to be made. Please note that this section 161 subsection 4 is applicable only in case a person who is appointed as a director only in general meeting. A person such as alternate director, additional director who is not appointed in general meeting, in those cases these provisions are not applicable. So this is only applicable to those who has been appointed by the company in general meeting. Now, filing of casual such vacancy. So how will you file this casual vacancy? So this is to be filed by the board of directors at the meeting, which is to be subsequently approved by the shareholders and the members in the next general meeting. The filing of casual vacancy in this manner. What would be the term of the office? Now, the person appointed shall hold office only up to the date up to which the director in whose place he is appointed would have held office if he had not vacated the office. Section 162 subsection, section 162 and section 163 talks about mode of appointment. How a director is to be appointed. Most of the cases, every individual director is to be appointed by a separate meeting, by separate resolution into the meeting. A director would be named, his name would be proposed into the meeting and a resolution will be passed for each and every director. But in case a single resolution can be passed for the appointment of all the directors, but if it is only agreed by the members in their first meeting. So please read this second number point. Okay, so this is what we have to discuss in this particular point. Let me read what is this. A director appointed on the principles of proportional representation under section 163 cannot be removed by ordinary resolution as aforesaid. Please read through this particular this thing. Now, appointment of directors through proportional representation, I would recommend you to kindly read it yourself, very easy to understand. Now, moving on to the next provisions, disqualification for appointment of directors. Now, who is disqualified to be appointed as a director? So, I have highlighted the most important parts over here. Kindly read it yourself. Once you read it, you will be able to easily understand. Let me discuss point number 6. If a person who has been ordered for sentence for imprisonment for a period of 5 years and 6 months is not left for the completion of that 5 years, then that person shall not be appointed as a director. If the period of 6 months is expired, then only he can be appointed as a director. Apart from this, if a person who has been convicted by an offense and has been sentenced imprisonment for a period of more than 7 years, then for the lifetime there is a ban for his appointment as a director into the company. So this was the important point over here. Kindly read it. MCQ can be formed from this particular point also. That's all. I think this is not relevant. Kindly read. These are very easy to. Okay, if he fails to repay the deposit or pay the interest, okay, other disqualification. A person shall not be appointed as a director if he fails to, he fails to repay the amount of dividend which has been declared in the another company for a period of 1 year or more. Kindly read through this limit also. This is also very important from the exam point of view. Apart from this, I would say, yeah, this one, holding of maximum number of directorship. What is the maximum number of directorship a person can hold? I am an individual. What is the maximum number of directorship I can be into the company? So the maximum number of 20 directorship I can hold in different companies. After which maximum 10 should be in public companies. Public companies will also include your subsidiaries of public company. So matlab 10 would be public companies out of 20, including your subsidiaries of public company, and 10 would be other companies. Let's say one-person companies, small company, your private companies, any other kind of company. But this one, dormant company is being excluded from this particular directorship of 20, the limit of 20. So the limit of 20 is not applicable in case of dormant company. This one is the point which I wanted to discuss. Apart from this, now this 20 includes also your alternate directorship. If you are holding alternate directorship for any other director, then also the 20 limit is also considered for this directorship also. Now, maximum holding of directors shall not apply to section 8 companies. In case of section 8 companies, you can be a director in any number of companies. Now, the duties of directors, not so important from the exam point of view. These are general questions which were used to be asked in descriptive, when the examination was in kind of descriptive. Now, what is the penalty for contravention? Rupees 1 lakh to rupees 5 lakh rupees of contra penalty is there applicable for you. Vacation of office. This one you can see, on absence from meeting for board held during a period of 12 months. If a person who is not present in the board meetings in the last 12 months, previous 12 months, if a person is not present in any of the board meeting, then he shall be eligible to vacate the office as a director of the company. This one is important point over here. Apart from this one also you can see this one we will be covering in the board meeting wala chapter. This one, yeah, convicted by a court for any offense and sentenced to imprisonment for not less than 6 months. A person who has been convicted by a court and sentenced for more than period of 6 months, then he has to vacate the office as independent director. All right. Now, resignation by director. Director may by himself can resign from the company by giving a notice in writing. Board shall on receipt of the notice shall take note of the same, and company shall within 30 days intimate to the ROC. Company shall place the fact in the general meeting also, and director may forward copy of resignation to ROC within 30 days of the resignation. So this is what one of the provisions. Now, removal of director. How do you remove? By passing a ordinary resolution, by passing a special notice is to be required to be sent, and on receipt of the notice of resolution for removal of shall send a copy thereof to the concerned director. Director shall be given opportunity of being heard, and director concerned is entitled there to make representation in writing to the company and request his notification to the members. So this one provisions I would recommend. Now, restriction on removal of certain cases. Now, director appointed by tribunal under section 242. If you are somebody who has been appointed as director under section 242 by the tribunal, then you cannot be removed by any person. Independent directors who are reappointed for second term under section can be removed only by passing of special resolution plus opportunity of being this to be provided to them. This is only applicable in case of an independent director only. Now, directors appointed under section 163 who has been appointed are not, there is no restriction on removal of certain directors. So this was the complete revision of your chapter number 1, appointment and qualification of directors. If you like the video, please share it to your friends. Please like the video, please subscribe to the channel, because this gives me a motivation to post the next video. Thanks a lot for watching. Thank you so much.